Hello, welcome to Senior Moments. My name is Dolly Simunovich. In 1994, my mother passed away. Stunned by his loss and facing his own mortality, my father went to an attorney and set up a trust. Well, last year my father passed, and he had set up 2 of his children as trustees, and we were immediately able to write checks on his accounts and take care of his business. All of his accounts, as well as a safe deposit box, were open to us. That small amount of planning really paid off. We didn't spend any time in court. We spent it in the loving arms of our extended family. What a gift. In California, with the value of homes, estates can get rather complex. Dying without having a plan can put your estate in probate and cost your heirs an enormous amount in court costs, attorney fees, as well as time. I'm here today with Lori Adashevitz, attorney at law who specializes in estate planning. Welcome, Lori.
Thank you so much.
What is estate planning?
Estate planning is the process of bringing the future into today so that you can do something about it now.
Okay, now what does that mean?
It means making plans for yourself, for your health care, for your family, and for what happens to your assets if something should happen to you.
But we don't know what the future is going to bring.
That's true, but that's why you need to make plans in advance so that you can cover the contingencies. Lots of things can happen. No one ever expects to be hit by a bus or to suffer a traumatic illness that would leave them incapacitated. So it's important to think about those things. How would you want your life to look if something like that were to happen to me? Lots of people think about, the eventualities. Oh, I'd have to move to a nursing home. But there are options. You can plan to have in-home care. You can make your wishes known, which makes it much easier for your children to take care of you in the way that you really want to be taken care of.
Well, who would get estate planning? When would you get it? Who would want it?
I think everybody needs estate planning, even at a basic level. There are healthcare directive forms. Everybody's aware of Terry Schiavo.
Yeah.
And she was in that situation precisely because she did not make her wishes known to her family. And so even at just that level, if it's just with the healthcare, then people need to make their wishes known in writing to allow those things to happen when the time comes. In terms of assets, there's also, in California, we have a crazy probate system. And so anybody that really owns a home or any assets over $100,000 is likely to end up in the probate court system if something were to happen to them.
And estate planning makes that transition easier? Is that what you're saying?
So much easier. Our statutes include specific fees for attorneys and executors when they probate an estate. And those fees are very high.
Are they?
They start at 4% of the first $100,000. 2% of the next $100,000, and they increase up to $1 million. It's 2%, and above that, 1%. And of course, the legislature adjusts these from time to time, but that becomes very expensive. It's calculated on the fair market value of your assets. So, for instance, if you have a mortgage on your home, they're going to still calculate it on the fair market value of the asset and not discount it for the mortgage that you may have.
So what you're saying then, without estate planning, if you have to go through probate, most of your assets go to lawyers instead of the people you want to have them.
Well, maybe not most of it, but for instance, if you own a $1 million home, which is about average here in the Bay Area, you're looking at spending about $50,000 to probate that asset, that one asset. And so if you create certain plans, you can really work around that and keep those expenses to a minimum.
So it's less expensive to talk to a lawyer on this end than it is for your children to talk to a lawyer on that end. Is that correct?
And a lot less stressful, I'll tell you
I'm
that.
Sure.
I've had children come to me when their parents haven't planned, and they never know. They don't really know, even just in planning funeral services and things like that. They don't know, and they love their parents. They want to do the right thing by them, and those are the children that are most likely to get the most expensive casket and the most expensive service. And if that's not in line with what that client really wanted, they could have prevented that and used that money for other things like children's education or grandchildren's education.
So what kinds of things are included in estate planning? If you
Estate-
use vehicles, you use different vehicles in estate planning, is that correct?
Yes, we like to paper the world.
Yes, okay.
We do start with a trust. That's the primary vehicle in California, or the primary document in California. And a trust is a great thing because it protects you not just only in the event of death, like a will would, but it also helps to provide for you in the event of an incapacity. So if you're incapacitated, you can have it set up in your trust where it says, if not, I'm not able, then I'm passing control to the next person in line. It could be a son or a daughter or a bank sometimes, because we don't necessarily want our children to have reasons to have conflict. So a lot of people do choose third-party corporate or banking trustees to help minimize the chance of conflict in a family. So there's the trust, there are wills, there are the healthcare directives and documents that relate to your own well-being and care, and then durable powers of attorney, and that helps manage things that are outside the trust. So say it was that bus that hit you, you would have legal rights to sue the driver in the bus company or whoever was involved in that accident and get the money that they would need to provide for your medical care. So that's not a right that a trustee would have, so you need a document that's going to cover those sorts of
That's
circumstances.
the durable power of attorney.
Yes.
That would be in the trust.
Yeah, well, it's a separate document.
It
So
is.
we end up with a complete plan. I usually provide about 17 different documents.
Really?
For a married couple.
I see.
We put everything together in a portfolio, and they're all separated so that you know which document is which, and they all serve a different purpose. And so with the documents, it's easy to lump them into one, but what they're designed to do is provide a seamless net of protection. Because where the trust ends, then the durable power of attorney can pick up, and where those two end, then the advanced healthcare directive can take over.
And what is that?
That's where you're actually giving somebody discretion and authority to make your healthcare decisions for you. So this can include anything from signing releases or documents when you go into a hospital, or making those end-of-life decisions like Terry Schiavo's family were facing.
So if you're in a coma,
Right.
you have somebody else who can, well, now husbands and wives already can make those decisions, can't they?
Yes and no. In practice, there are certain decisions that the hospital will definitely go to the husband or wife for, but if there are people contesting it, that makes it a little bit more difficult. So if you've got children who say, oh no, let's hold on to mom, and a husband that says, well, no, I know that this is what she'd want to do, the children could go to court to prevent dad from unplugging that machine.
I see. In that document that you were talking about, what was it again?
Advanced Healthcare
Advanced
Directive.
Health. Okay, and that would stop that from happening.
It can
Because
help to prevent it, for sure.
Well, it would let the court know what you wanted.
Right.
So I see. Okay, and in the presence of an attorney, which makes it
Yes.
all right.
Yes.
Okay, well then what is a will? We've all heard of wills.
Wills are the old-fashioned way of planning your estate. They serve the purpose of directing where your property would go in the event of your death. They're important for younger families who have children because they're also the document where we appoint guardians for minor children. So it serves those two purposes. It does nothing at all during life, but does help during death for those two purposes.
Okay, I'd like to continue a little bit on that will, but let's take a break now, and we'll be right back.
I'm Sergeant Dan Steidle from the Pacifica Police Department. I represent the Consumption of Alcohol Suppression Team, also known as the Coast Under 21 Task Force. We need your help. Do you know of a business that is selling alcohol to minors, or of a location where minors are asking customers to purchase alcohol for them? Please contact your local police department if you do. Together we can combat the problems created by underage drinking. We thank you for your support in our efforts to protect our most precious asset, our children.
Welcome back. We were just talking about wills, and you said wills. I think your statement was that wills is the old-fashioned way of taking care of your family. What did you mean by that?
Well, wills do land you directly into the probate court. They're only really effective on death. And trusts are the modern day alternative.
But just a minute, let's go back to wills for a second. What does a will do?
A will direct the distribution of your property after death and or appoint guardians if you have minor children.
So how does that differ from the trust?
A trust is an arrangement between three parties. You've got the person with the money.
Okay.
You've got the person who manages the money.
Okay.
And you've got the person who benefits from the arrangement. When my clients come in to see me, they fill all three roles and wear all three hats at the same time. So they're the person with the money, they're going to manage it themselves so long as they're alive and able, and then they're going to also benefit from that arrangement. The only time that changes is if there's an incapacity or a death. In that case, there's somebody else set up to manage the funds, and that role is called the trustee. So the trustee, if that's the name that's on title, those assets will not go into probate court.
So the assets no longer belong to the person, they belong to the trust. Is that what you're telling me?
On paper, yes.
Oh, okay, but they have all the use of it and they have total control of it, even though it was still in their name.
Yes, and it's a revocable trust, so they can cancel the trust at any time and take them back.
They can add things to it if they want to. They can change it in any way because they have total control over the trust.
That's correct.
That's what you're telling me.
Yes.
I think that's the scariest thing for seniors especially, or anybody, you know, the fact that they might be giving their stuff away to a document or to an entity, and then they lose control over it some way.
Right.
So you're saying that doesn't happen?
No. It stays within that person's name as trustee, though, rather than as an individual.
I see.
So as trustee, they can save themselves much of the expense and hassle of the probate court system. Yeah.
If someone has a trust, what happens when they die?
When they die, the next person that they've nominated in their trust, now it's a person or a company hand-selected by the client to take over, they take over. Notices are sent out to various individuals, just like in probate court. It's all the same actions that are taken in probate court. So they want to notify everybody, they want to gather the assets, take an inventory of all the liabilities, all the debts that there might be out there, and make sure that those people are paid, and then distribute the assets to where they want to go.
So they pay the bills and distribute it to the beneficiaries, and then what happens to the trust?
The trust can either continue if it's set up that way, or it will terminate. So one of the two.
I see.
And that just depends on what decisions the client made when they designed their trust. I'll tell you, a lot of people these days are worried about getting sued. And so now our office is doing a lot more asset protection or inheritance protection trusts. So those are different things that we work around, but ultimately you're in control of what you put in your trust. It can be drafted a million different ways.
So included then in that trust, there's the living will, and that tells...
Yeah, living will is actually a very specific document that talks about your desire to terminate life-sustaining treatment. So it's a very specific document that's just for those end-of-life decisions, and I keep that in a separate document from the Advanced Healthcare Directive.
So that doesn't go right in the trust, it's a separate document?
Separate document.
Okay. And so that allows the survivor to not even have to make the decision. Here it is, this is what my wife wanted, this is what my husband wanted. There's the document, do what she said, or do what he said.
Yes, and it provides a lot of guidance for that. Of course, when you're facing a medical situation, it's never black and white. So, well, okay, it's rarely black and white, let's put it that way.
Yes.
You can be diagnosed with something and may or may not make it, and really you're giving the person as much information as you can conceivably give before you're in that situation.
So what if there are changes? Let's say I set up my trust 3 years ago, 4 years ago, 5 years ago. What if I want to, things have changed. My son married someone else. Things have changed. I've got grandchildren and great-grandchildren that I want to take care of now. What happens then?
Well, an estate plan is a plan like any other, and it's subject to change. So when things happen in your life or in the lives of your loved ones, then it's important to reevaluate your trust and your entire estate plan. And I tell my clients they should read it every year. I'll bet you not one of them actually does, but
they might not be able to find it every year.
They better. They better. But they should read it every year to make sure they know what's in there. It becomes much easier in a time of grief if you know what's in there and what you can count on it happening. Again, you should know where they are, because if something happens, you may need those documents.
Should it be kept in a safe deposit box?
Well, that depends. If you keep copies of your advanced healthcare directive, or you have a service that makes those documents available 24 hours a day, then maybe a safe deposit box is a good idea, as long as you have access to the documents you might need in the event of an immediate emergency. So banks aren't open from usually 5 or 6 in the evening.
Nobody else can get in your safe deposit box either.
Well, there's that.
Especially if anything happens to you.
Exactly. So you need to create a mechanism. Maybe the next person in line, or banks often have a limited power of attorney or permission to allow somebody else into that safe.
Now, if you kept it at home and there was a fire, or it was destroyed or someone, would you have a copy too?
I keep scanned copies of absolutely everything that I draft and sign with my clients.
So it could be replaced if they lost it?
It can be replaced, absolutely. In fact, everything is saved electronically. It would be very easy to re-execute all those documents. And I would still recommend doing that while the client is still alive and well.
So husband and wife should really discuss with each other what they want. Do they trust this person? Do they like this? Do they like that? How do they want this? How do they want this done? And who do they want as their primary trustee if one or both of them should die? What if just one person dies? The husband and wife have a trust in their name. What if just one of them dies?
It typically is set up to continue to provide for that surviving spouse.
And then the surviving spouse is just the trustee?
Usually.
Okay.
It may not always be the way, but usually that's the truth, especially with long-term marriages, and if you have the same children. Blended families might be a little bit different, which is increasingly common these days. But a lot of those decisions, again, are made between the family, between the husband and wife or an individual. But a lot of those times, I'll tell you, it's one of the funnest things about doing what I do, is that I get to talk with clients about issues that they've never talked about with each other.
Really?
Yes. So
You're like a marriage counselor.
I am. And most of the time it's fun, and sometimes it's tense, but I'm used to doing that, and it's so much fun letting them see that the possibilities of what they can do, but also to learn things about each other that they haven't known after 30 years of marriage.
Okay, now so far we've been talking about people all ages. Is there anything specific for people over 50 or 60 or 70 or anything that you can think of specific to them?
When I'm talking with seniors, especially in that 50-year-old range, I really like to talk to them about long-term care insurance. I don't sell long-term care insurance. I can't as an attorney. But I think it's a wonderful way to protect yourself and your assets, and also make sure that you're really taken care of in a way that's going to be suitable. So that's one of those things, just really start looking at either.
And it's a lot more less expensive at those ages than if you try to get it when you're 70.
If you can get it. And so if you develop a healthcare condition later on, you may not be able to get it. So I really start encouraging them to at least get quotes, consider it, because a whole year's premium is going to cost less than 1 month in a skilled nursing facility. So that's one way to really protect yourself. Beyond that, I talk to the grandparent level client about gifting. If their estate's at a taxable level, if they're talking about providing for their grandchildren's education, and really talking about the things that really get them fired up. Some people really have their favorite charity, whether it's a church or an animal shelter or different things like that, really making a difference.
And they'd like to gift through their trust? Is that what you're talking about?
Gifting plans either through their trust or even during life, because it's so much fun to watch people or a charity enjoy your money, your funds that you've donated. Gifting to a grandchild, which allows them to go to college, is very rewarding. And money really is only money. And being able to see people enjoy life or follow their dreams because of it, that's what makes it really important.
Right. I understand that there are some places that you can go to do it yourself. What's that all about?
Yes, there are places like Nolo Press or paralegal services that will prepare documents for you. They're not permitted to counsel you or provide you with advice as to how those documents should be written. So a client would need to go in and say, draft my trust this way, I choose this, and then that sort of service can prepare the document exactly as you've told them to. This may not produce the best result for a lot of clients because, again, they can't counsel you or provide advice.
So they don't keep up on the laws. They only keep up with the documents that you ask for.
Maybe.
And maybe?
Because they're not licensed to practice law. And so their liability to you is very minimal because they're just acting at your direction. Attorneys go to law school. We have continuing education requirements. Many of us carry professional liability insurance. So if we do something wrong, we are truly accountable to our client and our client's families. Whereas that's not necessarily true if you get, the will maker software. Where are you gonna go when something goes wrong, or when you have a question, or where do your children go when the document isn't quite clear? Our office has had a lot of those documents walk in the door where there's no trustee named, there's no actual distribution provisions included, where it just says, here's my property, it's in trust, and very, very important, crucial provisions are just not in there. And it ends up costing the family a lot more because we then need to take that document to the probate court and try and interpret it and have the judge say, well, this is what I think it really was intended to say.
So even if you've done a lot of homework on your own, who wants to read law books? Except you. Okay,
I do.
But even if you've done a lot of work on your own, there are things that you could probably forget.
All sorts of things.
Like what?
And things that aren't even necessarily legal. For instance, if you say, I really want my son to get married, and I leave him my inheritance so long as he's married by the time he's 30. Well, that's not enforceable. So he could go to court and say, you know what, this is silly. I'm not going to get married. I don't want to get married, and this should be invalidated, and he would win. Because those sorts of provisions are against public policy, and there's no way for the average person to know this unless they're doing this for a living. If that average person happens to also be a lawyer.
And how about pets?
Oh, pets are one of those forgotten people or heirs. My pets are very dear to me, and people don't think, well, hey, if I'm incapacitated, who has the authority to get in and feed my pet or to take care of my pet, and who ultimately will care for that pet? So it's been on the rise where we've been doing pet trusts to provide some fund of money, yes. You can provide a fund, well, doesn't need to be $12 billion like Leona Helmsley, but you can really help out. So if you have a friend or a neighbor who just adores Fluffy, that you can also provide them the money to take them to the vet annually and provide them with their good quality cat food or dog food, and make sure that they're really cared for in the same way that you would have wanted.
So my point is that there are just things that you would probably think about because you've been experienced in it, that you're not going to get on a do-it-yourself website, or even if you do a little research on your own. The internet, everybody's researching everything themselves.
And I think that's a good place to start. There's a lot of good information on the internet. My website itself has a lot of information, and in fact, specifically on pets. One of the things that you can find on my website is a caretaker funds calculator.
Oh, really?
So a spreadsheet. How much do I spend on this and that? But those sorts of things truly come with experience. And our office not only plans estate, but administers estates after an incapacity or death. And I'll tell you, we learn a lot from going through the courts or different situations that happen when the incapacity occurs. And there's just no way to provide that information necessarily in a book or software program. So really it is a counseling process as much. I consider I tell my clients, the documents are the period at the end of the sentence. So really it's our conversation that really will get us to where we want to go.
Well, it's been my experience too that when you sit a husband and wife down together, they had never really talked about any of these things, and just you as the mediator find out what each person wants about it. Because you know yourself, one person kind of takes over the conversation and does all the talking. The other person just sits there quietly unless you ask them and what do they want and what do they think, etc.
And that's true, and it may make their marriage wonderful, because if you've got the give and the take and they've come to their own equilibrium. but you have a right to do with your property and to make your own healthcare decisions the way you want to. And so there are ways to do that in one estate plan where each person's getting what they want and doing with what they want with their assets and healthcare. And so it doesn't have to be an either or. There are often ways to achieve both. And that only comes with working with someone who's skilled at figuring out how to achieve both.
Well, how do you recommend that people find an attorney that, you believe that they should find someone who specializes in it, don't you?
Oh, absolutely.
And why would that be?
The people who dabble in estate planning don't necessarily keep up to date with not just the laws, but the better way of doing things. We have something called best practices, and we stay on the cutting edge, and it really is what we live and breathe. And I'll tell you that's way too true, but there are things that you just don't get exposed to unless you're doing it all day, every day, day after day. So there are groups like the state bar, even local bars will have estate planning sections. So finding somebody who's really committed to knowing about this area of law is important. I also belong to a group called Wealth Council, which is a nationwide group, and they have a website that you can go to and look for attorneys in your area, and all of those people are committed to providing the best quality services to their clients. So I think that's a great place to go as well.
Now, you have a website too, don't you? And what would that be?
I do. It's baylaurellaw.com, all one word.
And and what do you have on there that would help people?
Well, I have information on how to choose an estate planning lawyer, questions to ask if you're interviewing estate planning lawyers, but also we've got some fun tools like the pet caretaking funds and different information on what to gather if you're going to go see an estate planning lawyer. So all that's available with tons of information, and it's a good place to get started.
I thank you so much for your information. It's been a delight to talk to you, and thank you so much.
Well, thank you for having me,
Oh,
Dolly.
you're welcome.
I love to talk about my stuff.
Oh, great. We'll be right back.
Come on, man, that's not cool. Pick that up. Good job, buddy.
Peer pressure works. Put the trash in the can.
Sometimes you don't know what you need or even what's available to you until you discuss it with a professional. The ensuing peace of mind is invaluable for making your remaining years comfortable for you and your loved ones. Thank you for joining us today. I hope you enjoyed our program. See you next time on Senior Moments.